bringing in people from out of our organization, but every now and then we realize we have the talent right here we should call upon. We chose ERISA. It's been hitting the listserv as a subject. It's been around for a long time, obviously, but it's hit our radar screen again. There was a 2-hour seminar put on by the Multnomah Bar Association here just a few weeks ago on ERISA. I attended that, came away realizing, as is the title today, what few rights, if any, our clients have representing the insureds under these policies. So we came up with the title, we should know what few rights our clients have. Tom, bless his heart, has taken a little bit of liberty with an additional headline on the written materials. And I'm going to turn it over to Megan Glor and Tom Diamore. Let you guys tell us. Thank you.
Good afternoon. What we plan to do is I'm going to give a brief introductory, and then I'm going to have Megan kind of talk to you about the nuts and bolts and the brainy side of ERISA, and then I will talk about the practical side of reimbursement so that I can stay away from the brainy side of it. What I've done is given you all a packet, and there's an outline in the front of it, and what I've done is trying to give us plaintiffs' lawyers some of the key things that we can rely on, because I know for most of us we avoid federal court like the plague, and since we do that we don't read federal cases. But my point being here is that us state court people, when we're dealing with ERISA plans, we have to read these federal cases. And so I've included copies of the cases at the end. And I would say to you, that's the first place that you should start, is with those Ninth Circuit cases. From the folks that I've talked to, it's quite a surprise. And the theme is basically, you do not have to reimburse an ERISA plan anything as the Ninth Circuit cases read. The Ninth Circuit is in the minority on this issue, and the insurers are desperate to get this to the Supreme Court. But I'll talk a little bit more about that later. This is the one time where, we all know ERISA is very, very bad for our clients. This is the one chance where we get to actually use ERISA against the insurers, and it's kind of a pretty good feeling. But there are risks and there are pitfalls, given that they are trying to get a case to the U.S. Supreme Court. But before I go more into the reimbursement, I'm going to have Megan talk to you about her topics with respect to ERISA.
Am I supposed to put this on? Okay. Great. I wanted to start by giving you 3 examples in different areas of ERISA that will show you some of the horrors that we're up against with ERISA. The first one comes from a 1999 Northern District of California decision, absolute travesty of justice. District Judge Fern Smith just went way, way off track in this case. This was a disability case. She found that in this case, the standard of review, and we'll talk about that in a few minutes, the standard of review of the plan's decision to deny disability benefits in this case was an abuse of discretion. And then she went on to find that under the facts of that case, the plan had abused its discretion by relying on a non-specialist reviewing medical person to determine that the claimant was not disabled under the plan, and discounting the treatment of the opinion of the treating specialist. When she found the abuse of discretion under quite a bit of Ninth Circuit law, including Snow versus Standard Insurance, that's the main case on this topic that I know about, that should have been the end of the story. She should have awarded benefits, and instead what she did was she remanded the matter back to the Hartford to make, her words were, further consideration of plaintiff's neuropsychiatric condition to see if it would be a basis for denial of disability benefits. So guess what the further consideration consisted of? The Hartford went out, got 2 more expert medical opinions to shore up the administrative record, denied the claim a second time, and now this person has been waiting for 5 years on her claim, has never gotten any benefits, And I've just heard that the plaintiff's attorney wants out of the case. What a surprise. The second case, Bast versus Prudential, very sad case. People here may know about this. Plaintiff diagnosed with breast cancer. Her physicians recommend an autologous bone marrow transplant. Prudential, the administrator of an ERISA health plan, denies pre-authorization. And after a number of lawyer letters showing them why they're incorrect under their plan, Prudential reverses and agrees to authorize the bone marrow transplant, but too late because her window of opportunity had passed, and in that time she wasn't able to afford to pay for it out of pocket and get reimbursed. She ended up dying. Her surviving spouse brought an action against Prudential alleging negligence and bad faith. The district court, upheld by the Court of Appeals, Ninth Circuit, held that ERISA preempts state law claims even if there's no alternative remedy. The Ninth Circuit said, "We affirm, although this case presents a tragic set of facts, the district court properly concluded that under the existing law, the Basts are left without a remedy." And finally, a very recent case, Gorbani versus PGE. This is out of the Northern District of California. Judge Walker found the plaintiff's ERISA disability case to be anemic, not a good case, granted defendant's motion for summary judgment, and then get this, also granted defendant's petition for attorney fees, which is very rare under ERISA. There's generally a presumption that plaintiffs get fees, but defendants don't. But then went on to hold that where the plaintiff's attorney has a contingent fee arrangement with their client, the plaintiff's attorney is liable for the defendant's fee. 12 lawyers who do a whole lot of ERISA work offered to assist the lawyer on appeal, and he went on and settled it by paying the other side $1,000. Occasionally the court gets it right. In Booten versus Lockheed, this was argued a few years ago. Judge Kaczynski hit the nail on the head during oral argument. Lockheed's lawyer argued that, well, yes, the denial of benefits in this case might not have been morally correct. That was the term he used. But under the abuse of discretion standard of review, it was legally correct. And Judge Kaczynski looked at defense counsel and said, every once in a while we get the opportunity to make that which is morally correct also legally correct. And they did. ERISA is so difficult because under ERISA in general, there's no right to a jury trial. There's no right to extra contractual damages. The standard of review, more and more, is abuse of discretion. The evidence is generally limited, and this is a big trap for the unwary. The evidence is generally limited to the evidence or the claims file, what was before the plan administrator at the time they made their decision. So once, if and when you get to trial, the trial is really nothing more than a sort of summary judgment hearing on the administrative record. And often lawyers don't know that until they're way down the road. They filed their claim against the plan, and what they're faced with is this very slim record that they haven't really contributed to. And preemption. Most state laws and remedies are preempted. I'm going to start by talking about what is an ERISA plan, and then I'm going to go into the claims, jurisdiction, those sorts of issues, what you need to know about that. Then a little bit about preemption, the standard of review, which is where most of the battles are being fought right now, and then what is a full and fair review. What I'm going to say applies, much of this does apply even in the health lien reimbursement context. It is especially important, or in some cases more important, when you're handling a claim, for example, disability benefits, life insurance benefits, et cetera, under ERISA. So, but the first thing that this has been a topic on the listserv, is it an ERISA plan? And it's come one of two ways. The plan says we're an ERISA plan so we can do whatever we want to do. I don't think it's an ERISA plan because, or the plan says we're not subject to ERISA because they hate the rule of the Ninth Circuit about reimbursement. So there, this is based on, I think it was an email that maybe Wendy and I were doing back and forth about, Wendy Squires, about what is an ERISA plan, and it's in the second or third section of the materials. It's entitled, Is it an ERISA plan? And what I've done is laid out the steps for determining whether a plan is an ERISA plan. Basically, we're talking about group policies that are for the benefit of employees that are established or maintained by the employer. The big exceptions to ERISA are public employee plans, federal, state, local workers, private policies of insurance. You go out in the open market and buy a health plan or buy a disability plan. That will be exempt from ERISA. Voluntary employee pay-all plans, and what those are is the employer allows an insurance company to come into the workplace and make their sales pitch to employees, and the employees can decide whether or not they want to buy the plan. Unless the employer is taking some active role in administering or maintaining that plan, generally those plans will be, just like the case where you go out in the private market, they'll be deemed employee pay-all plans and will be exempt from ERISA. And the other one, this comes up in the context most often with short-term disability plans, and those are payroll practices. There's not actually a trust set up, but at least for the short-term disability benefit, the employer is paying benefits out of its general assets. It hasn't created a committee to evaluate claims, and it hasn't set up a trust the way that it's done under ERISA. Those are generally exempt from ERISA. And in those cases, what you've got is a breach of contract claim that you bring in state court. Sometimes it's removed to federal court, but state law is going to control and ERISA is not going to control. I've laid out 6 steps that I generally use to determine if the plan falls under ERISA. And as you can imagine, under each one of these steps, there are probably 50, 60, 100 cases. So the law is all over the place. But in general, the first step is to determine whether there is a plan or a fund or a program. And there doesn't have to be anything specific in writing. The idea is, can you determine the intended benefits, a class of beneficiaries, the source of financing, and the procedures for receiving benefits? There has to be a systematic procedure for paying benefits to give rise to an ERISA plan. It doesn't matter that the plan, usually it doesn't matter that the plan didn't file the correct papers with the Department of Labor. They may get penalized for that, but that's not the litmus test. The test really is, can you figure out from the documents that exist, discussions that exist. There's even a case where there's no written document, and the Fourth Circuit held that an ERISA plan existed. But can you determine these things? The second test is whether the plan is maintained by the employer, and the courts have construed this to find, in a case where it's a borderline case, they'll generally find that the plan is maintained by the employer. The employer has to do something more, generally speaking, than here's a claim form, good luck. Usually the employer is doing some of the bookkeeping work and giving direction to employees about filing claims, giving their opinions on things, and dealing with the insurance company, dealing with the insurer. So again, this one, I hesitate because the case law is just all over the place as to whether or not the plan is maintained by the employer. The question is always, is this a voluntary employee payroll practice, or is this plan truly maintained by the employer? The Ninth Circuit is better on that issue than any other circuit. The Ninth Circuit is more reluctant to find an ERISA plan where the employer isn't doing a whole lot or plan sponsor isn't doing a whole lot to assist with administration of the plan. And then the third step in this test is whether the plan provides certain benefits to beneficiaries or participants. And I've listed them out. There's some things that cannot be an ERISA plan because they're exempt under the statute, but in general we're talking about medical, life, disability benefits. There are some others that are more minor here. The fourth is there a statutory exemption? Those are the government plans. There are church plans that are maintained by a church. A workers' compensation plan, that's exempt from ERISA. Unemployment plan, these plans are exempt. And then the fifth step is there a statutory safe harbor? The primary one is the one I just spoke about. Is this a payroll practice where the funds are coming out of the general assets from the employer rather than a trust being set up? And then 6, is this a voluntary pay-all plan that falls under the safe harbor exception? And then on the next page, I'm not going to get into this, but I've mentioned some of the kind of red herrings, cafeteria plans and severance plans, et cetera. But in general, 95% of what I see is they are ERISA plans. The employer provided the plan for its employees, pays for it, takes a fairly substantial role in administering the plan, pitches it to its employees as even if the employees are paying a percentage of the premium, they pitch it to their employees as this would be a good idea or this is the plan we're going to endorse. And you're generally going to have an ERISA plan in that kind of case. Questions?
What about, can you tell us something about MEWAs?
I think I have MEWAs on there.
But I wasn't sure what MEWAs are not ERISA plans.
They are, most of them aren't ERISA plans. Gosh. Okay, yeah, the question was whether MEWAs generally are or not ERISA plans and how you tell. First of all, the law is really complicated in this area, and the cases are complicated. I don't think I really want to get into the analysis. What I'd probably rather do is post a little blurb that I have on the listserv or something so people can get it. Most of them, they are, okay. First of all, what a MEWA is several employers, this happens frequently with small nonprofits, will get together and they will there'll be one plan or a system of plans that different employers will use to provide benefits for their employees. Is probably not. I don't know. I'd have to look at the plan document. Probably it's not a MEWA. Usually, I think with the Multnomah Bar example, the Bar Association is all it does is arranges, it doesn't take an administering role in it, and that's the difference, as I understand it, yeah. One of the questions that comes up sometimes is which plan controls. The plan has been amended several times. Employee originally got benefits under one plan, then the plan was amended, and now there's another claim for benefits, so which plan controls? There's a very recent January 29th, 2001 case out of the Ninth Circuit called Gross, G-R-O-S-Z, Solomon. Horrible dicta in that case. That allow, and what that case says in dicta is that the plan that's in effect at the time of the denial of the claim or the termination of benefits is the plan that controls. And in the disability context, this is a horrible, if this becomes the rule, this is a horrible rule because what often happens is claimant has been on disability benefits since, say, 1990. That was back before anyone knew about these different standards of review and what the plan provisions would actually mean for the standard of review. The plans were written in a way that the standard of review was almost always de novo. And then in 1997 or 98 or 99, the plans amended because their lawyers have done a good job of reading the law. And now the standard of review is for an abuse of discretion. And then, bingo, in the year 2000, the person's cut off from their benefits are terminated, and the plan, if this is the rule, is the plan's decision is going to be reviewed for an abuse of discretion. So the way I see it working is the plan gets hit with a big claim and immediately goes out and does its homework and revises the plan description, and then IME, terminate the benefits, and the person's stuck with an abuse of discretion standard of review. So if that becomes the rule, then you know, no one's going to be safe from this stuff, even someone who's been on benefits for a long time. I'm going to get there. Yeah. Let me talk a little bit about claims and jurisdiction. Who can bring a claim under ERISA? An ERISA claim can be brought by a participant in the plan, that's generally an employee, by a beneficiary, that's often spouse, surviving spouse, or a fiduciary, which is usually the plan. The employer generally cannot bring a claim under ERISA. It's usually the fiduciary who is appointed under the plan to make claims decisions. So, for example, if XYZ company has a MetLife plan, it will generally be MetLife versus the plan participant if there's a lawsuit that's initiated by the plan. Venue is pretty much anywhere you want it to be, and that can be important on this reimbursement issue if you really go to the mat. As most of you know, the Ninth Circuit is the place where the law in this area, at least for now, is the best for us, and you want the claim to be in the Ninth Circuit. So if you're going to end up litigating, and in general, the Ninth Circuit is pretty favorable on the standard of review, which I'm going to get to next. So in general, you're going to want to be in the Ninth Circuit. The plan can go after, can go after your client and bring the claim in another circuit, and you're probably going to have a hard time having venue transferred to the Ninth Circuit. So just something important to think about if you're really going to get into it with the insurance company and it looks like a lawsuit's going to be filed. You probably want to be the plaintiff and not the defendant. The statute of limitations is not set under ERISA. There is no statute of limitations provided for in ERISA. It varies according to the claim, and what the courts say is we use the most analogous state statute. Generally, that's looked at as a breach of contract statute. Oregon has a statute that says that an insurer can set the statute of limitations for denial of benefits to 3 years after the proof of loss is due, and almost every ERISA plan that I see has that 3 years after proof of loss or proof of claim was due. So just be careful about that. Claims can be brought to recover benefits due under the plan, enforce rights under the plan, clarify rights to future benefits under the plan, enforce the right to get information from the plan, and there's information that you're entitled to under ERISA. For example, a copy of the claims file, a copy of the plan, and the plan can be hit with a penalty of $100 a day for every day it fails to provide that information. Unfortunately, the courts have been really reluctant to enforce that. In the case of Geldrick's Palmer versus University Medical Group, which is a District of Oregon case, there's a discussion about that where Judge Geldrick said, well, plaintiff really wasn't prejudiced by it, and the court, that seems to be the general trend, although ERISA says, I believe the word is shall, the courts don't seem to enforce it. And the last claim can be brought for equitable relief relating to the terms of the plan. What does the plan mean? Claims are generally brought as declaratory judgment actions in that area. What do the terms mean? Claims for attorney fees are discretionary. There's a presumption, I think, in every circuit that a successful plaintiff will be awarded attorney fees and costs. A successful defendant will not unless the claim is found to be frivolous. Unfortunately, another one, the Ninth Circuit hasn't, I don't think there's an opinion on this in the Ninth Circuit, but I think every federal court that's decided the issue has decided that if you win in the administrative appeal or any work that you've done in the administrative appeal, that work is not counted toward the attorney fee part, so you don't get attorney fees for your work on the administrative appeal, and probably 50% of these cases are resolved at the administrative level. Most insurers will routinely remove these cases to federal court, so you can file in state court. There's concurrent state and federal jurisdiction, but I don't think I've ever seen an insurer leave the case in state court. They remove it. Discovery, generally speaking, there's no discovery. You're pretty much limited to that administrative record, whatever was in front of the plan administrator when they made their decision. There are a few exceptions to this. One is you can get discovery to determine what the standard of review is. And I'll talk about what you might specifically need, but you're going to, if there's a doubt after looking at the plan as to what the standard of review is going to be, you can get discovery around that. And there's one other way that you can get discovery, and I'll talk about that in a minute too. But generally speaking, you don't get depositions, you don't get, I tried to get the CV of a doctor who the insurance company had relied on to, in denying my client benefits, and they refused production of the CV, so I couldn't even tell if the person was a specialist in this area or not. Fortunately, the court encouraged the plan to give me the CV so that I could at least make my argument. But so it's important before you are in court, while the administrative record is still open, to first of all load the record with as much information as you can, since the record is going to be all that the judge looks at, and also to demand documents under ERISA. Anything that the insurance company relied on in making their decision, I believe what the code actually says is any relevant documents, and I always argue the plan, any reports they relied on, any internal memoranda, correspondence, notes by the claims adjuster is relevant, and you're entitled to that. But just make sure you request it, if at all possible, at the administrative appeal level when you've still got time to supplement the record, because then you can attack what they're saying. Another big hitch is exhausting administrative remedies. Under ERISA, although it's not written into the code, you have to, the general rule is you have to exhaust your administrative remedies unless you can show futility or fraud of some kind. So it's very important, and the court will, there are strict timelines. There'll be generally, I just saw a plan where no timeline was specified, but generally the plan will say you have 90 days to appeal a denial of treatment under a health plan, of disability benefits, of pretty much anything under the plan. You've got 90 days to pursue your administrative appeal, and the company has to respond, and usually there's a second level of review. And if you don't go through that exhaustion procedure, if you just leave the claim and then file it in federal court, you're going to get hit with an exhaustion, a failure to exhaust claim, and the majority of cases, it seems, the courts have dismissed those cases with prejudice, unless there was some mistake in the denial letter where they didn't give you the deadline. They just said, well, you can appeal. That happens sometimes. They say, you can appeal. Please submit to us the appeal documents. Anything else you want to rely on, the sooner the better. The court will sometimes stay the case and let you go through the administrative appeal level, but that's a big quagmire. I'll talk about standard of review next, and this is such a big one. The big case is Firestone Tire and Rubber. It's in the materials. The site is 109 Supreme Court 948. It's a 1989 case. In a nutshell, what Firestone says is the plan documents control what power the plan administrator has. Generally speaking, the rule is that the standard of review, the court's review of the administrator's decision denying benefits, or any decision made by the administrator, is de novo, unless the plan gives the administrator, and here's the magic language, the power to construe uncertain terms or determine eligibility for benefits. If the plan gives the administrator that power in no uncertain terms, then the standard of review is deferential, abuse of discretion. The old plans, you'll generally often have a de novo standard of review. The new plans, because there's been so much litigation on this issue, they will almost always have standard insurance companies. Most recent one is just so comprehensive because they've been burned so many times. They lay out exactly what the plan administrator can decide. But this is where the fight's now occurring. Language that's been around in insurance policies for decades and decades is now being litigated. What if the insurance company says, proof satisfactory to us? The Ninth Circuit has held that's not enough, and the standard of review in that kind of, with that language, will be de novo. When we determine not enough, we can decide blah, blah, blah. Well, if the blah, blah, blah is objective, it's going to be de novo, but if it shows that the insurance company has discretion, it's going to be for an abuse of discretion. The big cases in the Ninth Circuit are Kearney, K-E-A-R-N-E-Y versus Standard, 175 F. 3rd, 1084, and that's in the materials, and Bogue, B-O-G-U-E, versus Ampex. That's an older 1992 Ninth Circuit case. The Ninth Circuit has said very clearly, we're only going to find a grant of discretion where discretion is unambiguously granted or granted to or retained by the administrator. So, and the Ninth Circuit says this is consistent with established principles that you construe ambiguities against the insurance company. It's about the only place in ERISA where that rule actually applies. De novo review, what happens is the court is going to stand in the shoes of the insurer, look at all the evidence in the administrative record. You're still limited to that administrative record, but the court is going to stand in the shoes of the insurance company and say, what's the right decision in this case? So, you know, Dina Klein versus 5 real psychiatrists who, you know, the court may actually find that the person's entitled to benefits. They're going to be looking at, the court's going to be giving a much more thorough, their own judgment, the court's own judgment as to whether or not benefits should have been granted. Also, well, I'm not going to go. Abuse of discretion is the other more likely, most likely now, standard of review. It's a horrible standard. If the plan gives the plan administrator the discretion to construe plan terms or determine who gets benefits, that's going to be the standard of review. And the administrator can be wrong so long as what they did looks reasonable. The court's job is to review the decision to determine whether the plan's administrator or trustees acted within the limits of their discretion and whether the decision was reasonable. Some of the Ninth Circuit language, we defer to the administrator's decision unless it is clearly not supported by the evidence in the record or the administrator has failed to comply with the plan's terms. Even a wrong decision will be upheld if it's reasonable. And the plan administrator did not abuse its discretion even where its decision was directly contrary to most of the evidence in the record. There is another possible standard of review, or another, there's sort of a hybrid, and that's where the claimant can show a conflict of interest. And you'd think there'd be a conflict of interest in every one of these cases because, you know, look who's making the decision and look who's paying out benefits. But if the claimant can show that the insurance company is, the administrator is both making the decision, the decision whether benefits are granted or denied, or how the plan is going to be interpreted, and that's the entity paying out benefits, you've got the appearance at least of a conflict of interest. On the other hand, if it's a self-insured plan, the company has a committee that's making decisions. That's the administrative committee, and the company is also paying benefits. Again, there's the appearance of a conflict of interest. And you'd think, well, de novo review. Well, it's not that easy. You have to show not only the appearance of a conflict of interest, but that apparent conflict of interest has actually resulted in a conflict, so that the decision has actually been tainted in some way. That's another case where you can show that there is an apparent conflict on the face of the plan. You can get discovery to get into the conflict issue. Was the decision actually tainted? So in the Ninth Circuit, in several circuits, the courts have adopted sort of a sliding scale. Well, we apply the abuse of discretion standard, but we sort of make it a little bit more searching if there's an apparent conflict. So these standards, there was something going around on the listserv not too long ago. Someone had put out, does this standard of review issue even apply with healthcare reimbursement? And the answer to that, I think, is yes. If you look at the Barnes case, in Barnes, the first thing the court said was de novo review here because there is not that discretionary grant. And it becomes really important because when you get into things like the make-whole rule and is the attorney entitled to, is the claimant entitled to a reduction for attorney fees, if the plan is silent, query whether in the abuse of discretion context, the court is going to say, well, so long as what the administrator does is not abusive, is not unreasonable, we're going to let it go. So the standard of review, I think, is really important for in these reimbursement situations, not just in disability, life insurance, et cetera cases. The health plans are generally better than the other plans at putting in the discretionary language. The more I look at these, the more or compare them, the more I see that in the health plan context, the plans are generally pretty up to date, whereas in the long-term disability, short-term disability plans, often they're fairly old plans. They've been kicking around for a while. The insurance company hasn't tried to amend the plan for a while. So, but unfortunately in the health plan area, the standard of review is, it seems more and more, it's abuse of discretion. Preemption, yeah.
Can I make a comment before you stand up? You referred to the Glor case, which holds that the post-amendment plans can be applied.
Well, it's dicta, but I don't think that was the holding of the case, but yeah.
In any event, they held that
Yeah.
case. It wasn't necessary for the result.
Right.
Because they affirmed the trial court, but even the trial court had ultimately agreed that it
Yeah.
applied the wrong standard. What's important to bear in mind with that case and that rule, the amendability of health and welfare plans, is that the analysis is basically that ERISA doesn't require your rights under a benefit plan to vest.
Right, right.
It's different than pension plans.
Yeah, I'm glad you said that. That's important.
Many plans, including many of standard insurance companies on disability plans, for instance, include a term that say that a claimant's rights or benefits will not be adversely affected by amendments to the plan that are adopted after the person first becomes disabled or entitled to benefits. And that, of course, raises the question, has the plan not, by its terms, vested the claimant's right to benefits? So that, in response to the question as to what to watch for in the terms, it's a critical thing to watch for.
Right. No, I'm really glad you said that, and I meant to go there, and I forgot. But yeah, what the court said that in Gross-Solomon said that if the benefits are vested, if the employee is vested in the benefits, then the change in the plan can't affect them. And the language that they said, the employees have bargained for a vested right. And I don't know if it was the court. Yeah, I think the court in that case, maybe it was another case, pointed out that most plans provide, or many plans provide, I guess, that the plan can be amended at any time, and there isn't vesting. But it's interesting that you say that. I haven't really gone back in every plan now and looked for that, but
There's a district court case out of Texas that ruled on that basis in favor of
Oh, good.
claimants, but it appears to be the only authority.
okay. Good. Thanks. Let me go over to, any other questions on or thoughts on standard of review? I think the Ninth Circuit maybe has more cases on standard of review than any other circuit, and if you, Kearney is a really good place to start, or Shepherd-Ice Firestone, and you'll find 50, 60 cases. It's just incredible. Okay, preemption. ERISA is really broad. Preemption is very broadly applied, I guess you'd say, under ERISA. And most state and common law remedies are preempted by ERISA. One thing that this means is that claimants are required to follow certain rules. The biggest one is exhausting administrative remedies. There is a saving clause in ERISA that says, nothing in this subchapter shall be construed to exempt or relieve a person from any law of any state which regulates insurance, banking, or securities. So you think, wow, great. But then there's the Deemer clause, which comes right after that, that says employee benefit plans are not to be deemed an insurance company or other insurer, bank, trust company, or investment company, or to be deemed as engaged in the business of insurance or banking for the purposes of the law of any state, blah, blah, blah. So the Deemer clause pretty much takes away what the saving clause gives. So the result is that almost all state law claims against plans, self-insured plans, are preempted. Bad faith claims, most courts have held, are preempted. One case, if you get into this issue of preemption to look at, is the Pilot Life case, U.S. Supreme Court case from 1987, where the Supreme Court said any law that has a connection or reference to a plan is preempted by ERISA. And since that case came out, most federal courts have interpreted ERISA to preempt any claim that's related to an ERISA plan. So very broad preemption. Recently, the courts have come step back a little bit on that. There's a case in the Ninth Circuit, well, the Supreme Court case is Verity. There's a Ninth Circuit case called Binns versus Exxon that was decided in August of 2000, and where the courts have allowed relief where misrepresentations were made in communication with the plan beneficiaries, generally prior to the adoption of a plan. In those cases, the typical case is employee goes to their employer and says, I'm thinking of retiring. Is there anything that's coming around the bend that could that would make me want to hang on? And employer says no, and then employee retires, and 30 days later, bang, the plan's changed, and this person would have had much more beneficial benefits or insurance benefits if they had stuck around. And there's a whole analysis under that. So that type of action is possible. Another more recent exception is estoppel. And generally, the courts are looking at promises that were made prior to the individual's entry into the plan. So there are a few exceptions to the preemption, to the almost total preemption of ERISA, but there's not a whole lot there. There are others, and again, there's so much on this issue, particularly in the medical malpractice context. Recently, there have been cases about preemption. Well, that a managed care organization can be sued for negligence, despite ERISA. For breaching standards of care, and has given a little bit more favorable interpretation to those kinds of claims, or venue to those kinds of claims. Full and fair review, one of the areas where you sometimes can get a plan, even under an arbitrary and capricious or abusive discretion standard of review, is adequate notice. Some insurance companies are pretty bad at telling beneficiaries what their rights are when their claim is denied, or what they need to do to improve their chances. ERISA, the regulations, the CFR lays out what must be in a denial letter. The denial letter has to lay out the specific reason for the denial, specific reference to the plan provisions that have resulted in a denial, a description of additional material or information that's necessary to perfect the claim, and a reasonable opportunity for full and fair review and the steps the insured or the beneficiary has to take. So sometimes you get a denial letter this comes especially from smaller plans that aren't very sophisticated. They'll send a denial letter, and basically the letter will say you're denied, you've got 90 days to appeal, but won't lay out any of the deficiencies in the person's claim, and won't refer to the plan provisions, the specific plan provisions that the plan relied on in denying the claim. And so there's a chance to do some good there where the plan has failed to do that. Unfortunately, generally the result in those cases is a remand to the plan administrator, saying, plan administrator, now tell the person, you didn't do it right the first time around, so now go ahead and do it right, and then you got an abusive discretion standard of review, and yeah.
What about a denial of benefits based on failure to reimburse the claim?
Say it again, a denial of benefits?
For failure to reimburse the claim.
Oh, so future benefits. Let's wait until Tom gets up here. He's going to address that, but yeah. Generally, your appeal is going to be your best shot, though, as I said before. So there's a good case on loading the record. Actually, two cases. One is Serbin versus Fortes, Fortes, benefits. That's a Northern District of Ohio 2000 case that's useful to look at. And the other one right here in the district court was, again, Judge Jeldrick's opinion in the Palmer case, Palmer versus University Medical Group. That was actually a claim also against Standard Insurance. Judge Jeldrick goes through many of the things that the plaintiff in that case had in the administrative record, statements from coworkers, observations of coworkers talking about how much her condition had deteriorated, statements from her doctors, just all sorts of stuff. I've taken to putting in photographs and even videotapes of my clients, thinking that, well, maybe, a judge gets a hold of those and sees really what's going on in this case. If you've got the right case, it's not a bad idea. So loading the administrative record is really where you've got, in my mind, your best shot, particularly where you have an abuse of discretion standard of review. One other little tip is to make sure that you get plan documents, all the plan documents. There's often a plan, and then there's also a summary plan description. Your client will often have the summary plan description or some kind of blurb. Sometimes the summary plan description is the plan. That's happening more and more now. But you have the right to those documents under ERISA, and it's really important to read them. First of all, to understand how the plan is funded, and second of all, to know really what your client's rights are and what the plan says, what its own language provides. Sometimes that can help you on standard of review. You'll be able to show a conflict where it didn't look from the plan description like you had a conflict. So you're entitled to those, and in the materials there's a section on sort of tips, and it talks about all the different things you should ask the plan administrator for. They have to provide those to you within 30 days, or again, there's that $100 a day penalty. So it's also a nice thing to kind of wave over their heads. Let me just...
What's the rule when there's a conflict of some sort between the summary plan description and the plan itself?
Yeah, the question is, what's the rule when there's a conflict between the summary plan description and the plan itself? There are a couple things here. First of all, the rule used to always be that whatever the claimant had access to, that's what controlled, because if there's some plan buried with the Department of Labor, if there's a document buried with the Department of Labor that the claimant never sees, then why should the plan shouldn't be able to hold the claimant to that? So the summary plan description controls. There is a more recent Ninth Circuit case that has the rule that where the summary plan description is silent, but the plan fills in that provision. For example, let's just say the summary plan description doesn't say anything about the make-whole rule. The actual plan does. Well, the plan, so long as in that case there is not a conflict, and what the plan says will control. So, if there is a discrepancy, though, or if there really is a conflict between the two, what the claimant had to rely on, generally the summary plan description, will control. I wanted to go back just for a minute to that case that I mentioned, Serbin v. Fortis Benefits. This is a really good case to look at if you're ever really comes under the make-whole rule, but if you're ever in the position of having to load the record, it's a good case to look at to see what you might load the record with. In that case, the claimant's position was, I haven't been made whole, and the court ended up determining that the make-whole rule was not excluded in the plan. In other words, the claimant was entitled to the benefit of the make-whole rule. However, there was nothing in the record that showed in what ways the claimant wasn't made whole. The fact that the damages that she had incurred were greater than the benefits that she recovered, were greater than her settlement. So the court really laid out the proof that you're going to need to put in the record if you're going to try to make a claim that your client hasn't been made whole. It's Serbin versus Fortis, F-O-R-T-E-S benefits. And I have only the Westlaw site, which is 2000 Westlaw 95340, Northern District of Ohio. I'm sure it's by now there's a site for it other than the Westlaw site. And I think what I'm going to do is turn it over to Tom now, and I may come back and talk a little bit more about the make whole rule or some of these other issues in a few minutes. Yeah.
Back on the statute of limitations, when would the limitation period begin for a carrier to initiate litigation against the recipient for their claim of reimbursement or equitable relief or whatever they want to call it?
Well, that's an interesting question. For the claimant, let me just start here. For the claimant, the statute of limitations has generally been held to start running when they get there. There was some case law saying when they get their first denial, but now it seems pretty well established that it's when they get their final denial. I don't know for the carrier whether it would be the final denial or whether they'd be entitled to sort of the benefit of that rule. So I'm not sure.
How about when they send you a letter saying we want you to sign this elaborate trust agreement?
Right.
Don't they have notice?
Right, that you're not. Yeah, we think so, yeah. Yeah. Good point. Okay, any other questions on just what I've covered? Okay.
And it's basically just a matrix with a few questions on it that I'm going to kind of go from. If you have any questions as I'm going along, feel free to interrupt me and ask. The normal PI case, it's a Steve Piucci case. It's an auto case. The carrier's offering 1.5. Well, you haven't got, in my example, you didn't get a chance to screw it up. The carrier's offering $1.5 million. Steve wants to hold out for the $3 million, but the client wants to settle it, so he settles the case for the 1.5. Takes his 40% fee, and he takes all of it. Okay. In the normal case, auto case, we're dealing with PIP, but a lot of times, either there's no PIP there or we've exceeded that minimal $10,000 of PIP. The next thing that usually steps in, if you do it right, is the employee's or the injured person's employer plan or their private plan. And as Megan said, when we're dealing with an employee and their private medical plan, 95% of them are ERISA plans. And normally we hear ERISA, we get a little bit nervous. But in our situation with reimbursement, ERISA is a good thing based upon the law in the Ninth Circuit. So the first question is on my matrix there, are you finished with the case when you obtain a judgment or settlement? No. You've got a lot more to do when you've got a lot of the benefits paid out via an ERISA plan. In Oregon, we are brainwashed because of the PIP statutes that generally in all cases we're going to be reimbursing the PIP carrier in full. You know, there's an exception, 7442.544, that never seems to apply. So for the most part, we are reimbursing the PIP carrier in full. And so us plaintiff lawyers even are brainwashed that we're going to just reimburse these carriers. The PIP carrier, you may have to do it. Reimburse them their $10,000. But when you're dealing with the ERISA carrier, you don't have to do that, at least in the Ninth Circuit and at least as the law stands right now. As I mentioned, and I'll talk about it a little bit later, there's some moves to get this in front of the U.S. Supreme Court. And any of you that have talked to these ERISA carriers, they do not like this Ninth Circuit authority at all. Initially, what they'll do, at least my circumstances have been, is they'll completely act like they don't know about it. I know they're having CLEs on this every day. But that's the starting point, that they don't know about it. And if you look at the plan provisions, they're pretty darn egregious. I mean, the plan provisions in some of these cases say you get no attorney fees and you must reimburse 100%. So if Steve's plaintiff has $1 million in meds and he's taken just a third of it, $500,000, under the plan, there's nothing left for the client. He gets his fee and the ERISA carrier gets reimbursed. So you got to get beyond all of that initially, and when you start talking to the ERISA carrier, make sure you've read, and I would say all 4 of the cases cited on the outline here, the Reynolds Metals case, the Cement Masons case, the FMC Medical Plan versus Owens, and Barnes versus Independent Automobile Dealers. That's the case. The Barnes case was the one we used to use to make the make-whole argument. But under these 3 cases, you don't even have to make the make-whole argument anymore. You can have it as a fallback that the plaintiff has not been made whole. And again, the make-whole rule is not like we Oregonians think, that the PIP carrier is going to get reimbursed. You truly have to be made whole, and that includes economic and non-economic damages. But under the Reynolds Metals case, Cement Masons, and FMC versus Owens, it's pretty clear in there that reimbursement is a contractual issue. And under ERISA law, the only type of money back that the plan is supposed to get is equitable type reimbursement. Yes?
The carriers are getting, they're fairly sophisticated. They know about the Reynolds Metal case. They know the Supreme Court took cert and the case was settled and denied. And they also know about the Knudsen case, which the Supreme Court recently took cert on. And I got a letter recently saying that hold the money in trust until the Knudsen case is resolved.
Well, I was going to get to that as part of my discussion, but I'll get to it now. That's an issue, and I've had that issue come up. And initially, when I started dealing with these cases, the position that I took was, you've got a contractual right to reimbursement. It's clear, the law is clear that you don't get it, that you simply do not get it under the law. Maybe the U.S. Supreme Court is going to change that at some point in time, but that's the law right now. But you need to make a decision because these carriers are very aggressive. And in my case, I went through the ethical issues. Am I supposed to put money in trust because somebody says that they have a contractual right of reimbursement and they just happen to be an insurance company? And my analysis was, I have an ethical duty to the client. If the client tells me, I want my money, I don't care what may happen at the Supreme Court, my feeling is that you're supposed to give that money to the client. The carriers strongly disagree with this, and Liberty Northwest, on one case where I kind of laid it out, I did all the CYA letters to the client and to the carrier and said, under the law, you clearly don't have a right to reimbursement, and I'm going to distribute the money to the funds to the client. Carrier responded, we're going to sue your client for the funds if you do that, and sent the CYA letter to the client. They say they're going to sue you if we pay you back this money out of trust. And the client said, I don't care, I want my money. They proceeded to sue the client in federal court. The client was long gone after he got his settlement. They got a default judgment against him, and they have been attempting to collect it. They haven't been able to collect it, so then they sent a letter to me saying, you have violated your ethical duty to the insurance carrier, which, yes, and we're going to file a bar complaint, and we're going to sue you because we didn't collect from your client. They haven't done any of those things, and the letters have been going back and forth with my ethics counsel and them about what's going to happen. And my ethics counsel is a former Bullivant guy, so he's very friendly to them. But since he's my counsel, I'm taking his advice. But at some point, I think my former client needs to try and reverse that, and I think he's got a great bad faith case if we can somehow get that thing reversed, or a malicious prosecution if we can't get it reversed, because the law is very clear that they did not have a right to collect that. So, having said that, the Mike Bryan approach is a little bit different than mine, because he wants to protect himself and he's been around a lot longer. But his approach is to tell the carrier, I'm going to distribute this money to the client. If you don't think I should, then you need to file something right now and get a judge to say to me that I can't release these funds. And I think at that point, you hold on to the funds if a court tells you to hold on to the funds. But I don't think a court should. I mean, the case law is so clear in the Ninth Circuit that you don't have to reimburse, that a court's going to say, sorry, carrier, I got to follow the law, you don't get the money. So that's the long answer to that question. You got your fee. Steve gets his fee. He didn't have to, because that's an undisputed amount. He gets to keep his fee. And in my case, the remaining amount that was held in trust before it was distributed, I didn't have any, luckily I think, I didn't have any right to a fee out of that portion of it. So it wasn't as if it came to me or a part of it came to me. It all went to the client. Nonetheless, they still threatened the bar complaint and to sue me, which we'll see if that ever happens. Okay. In answer to our first question, I think we've answered that. Once we have a settlement, you're not necessarily done with the case. I think a good thing to do at this point is to refer to the latest of the cases, and it's toward the back of your packets, and it's the first case listed there, the Reynolds-Metals versus Ellis case. And I just want to kind of highlight a couple of things from that case. This was a case decided February 10th, 2000, and it's true that this case was appealed to the Supreme Court, and then once they got it to the Supreme Court and cert was accepted, they dismissed it. I tried to get a hold of the plaintiff's lawyer this morning to find out exactly what went on with that and why, but my presumption is that this Knudsen case is a better looking case for the insurance carriers, and so they're probably trying to get that case in front of the U.S. Supreme Court, and there may have been something about Reynolds-Metals that they didn't like. Chuck? Well, they did. They settled it, but why did they settle it? Right. In other words, the carrier settled with the plaintiff in that case. And my question is, why did the carrier settle? Did they not like that case for some reason, and therefore they decided to settle it rather than argue the issue? And all of the insurance industry types, they're all filing amicus on these cases, and so it's a strong interest. And the Cement Masons case, maybe somebody knows, they requested cert on that a long time ago, and I just checked Westlaw, and it still is there as requesting cert, but I don't know what's been come down with that. So that's still another open one, and I really haven't read the Knudsen case, but I presume that that's the one they're going to try and move on. Now, when you're dealing with ERISA reimbursement, according to the Ninth Circuit cases, it's pretty simple. If they file in federal court to try and collect, you should quickly move for a dismissal of it. I mean, you don't even have to really get into it. You should be filing a motion to dismiss, and the case is done, and a dismissal on the merits so that it can't be brought back again. One of the questions that Chuck raised on the list is, what if they file in state court? Well, if they file in state court, they're in the wrong court. You could remove it to federal court, but who wants to get into all of that hassle? So what I would try and do is, based upon the federal law, the case should be dismissed in the state court and dismissed with prejudice so that they can't bring it up again in a federal court. Yes?
Tom, has anybody here had any success with either of those two?
Doesn't look like. And there's really not a lot of cases on the issue, except for the Ninth Circuit cases are very clear that if you've got a case filed in the federal court, it is simply dismissed on the merits. And again, the Reynolds Metals case is a good example. And the kind of the outline of the case in the beginning, the Court of Appeals held that claim not properly characterized as equitable within the meaning of ERISA subsection provided for civil action to enjoin violation of plan or obtain other appropriate equitable relief. So what they did in this case is they tried to frame their claim for relief as, quote, injunction or something equitable, so that they could fall under the ERISA equitable provisions. But the court in this case said, we don't care how you characterize it. The fact of the matter is it's not equitable. It's a contractual right of reimbursement that you're asserting. So you're not going to get into ERISA through this arguably equitable remedy. And so they dismissed the case. And I haven't got into the ERISA details, but basically the cases say, in order to make a claim aimed at enforcing the provisions of an ERISA plan, a plaintiff must fall within one of ERISA's 9 specific civil enforcement provisions, each of which details who may bring suit and what remedies are available. Unfortunately for the insurers, right of reimbursement does not fall under any of those 9 provisions. And that's one of the arguments that the carriers make, is that there's a footnote in one case that says you might be able to assert their rights in a state court or assert it in a different way. But I think Reynolds Metals stands for the proposition that no matter how you characterize it, you're not entitled to reimbursement. And in order to get your remedy, you need to go to the U.S. Supreme Court. And, you know, that is a risky proposition. If, for instance, in my scenario, as Chuck mentioned, if I tell the client that I'm going to give you these funds and you distribute them out, and then the U.S. Supreme Court case comes down and reverses the Ninth Circuit, if you're still within the statute of limitations, then they are going to be able to get that money back from the client. So as part of your CYA letter, you can't just tell the client, here's your money, don't worry about it. The Ninth Circuit says you don't have to reimburse it, because if the U.S. Supreme Court does reverse the Ninth Circuit, then insurers win and they can come back after your client for the money you've distributed to them. And given the U.S. Supreme Court's opinion of the Ninth Circuit, there's a very high likelihood that it could be reversed, just like the election was with George Bush. Yes?
My understanding is that the other circuits have gone the other way from the Reynolds Metals and Knudsen. Is that correct?
That is correct.
And that's probably the reason the Supreme Court took cert on it.
That's right. They have, I would say the majority of jurisdictions have gone the other way.
Yeah, I thought it was every jurisdiction, but someone on Listserv mentioned that there's one other that goes our way. I'm not sure if I think maybe it's the 6th or 7th.
And what's the rationale? Why do they say that they can go after them if there's no provision?
I try not to read those cases, but I think the rationale is that they are entitled to some form. This is some sort of subrogation / equitable right of reimbursement, and for that reason, the plan should be reimbursed. And there's a case, a U.S. Supreme Court Merton case, and in the Merton case, it held for the insurer, and the insurers in all of these cases, for the most part, are arguing that the U.S. Supreme Court in Merton says we're supposed to get a reimbursement. But the Reynolds Metals case distinguishes this type of reimbursement to the type that was in Merton. But I read the Cement Masons memo for cert, and they spent a lot of time, the insurance industry in one of their amicus briefs spent a lot of time talking about the Mertens case and why Mertens should overrule the Ninth Circuit.
Well, it seems like a way that both you and our clients could protect themselves is to see if the insurance company would go with a submission under Rule 66. You get a quick and dirty opinion that you can rely on.
I think you're right, and I'm not sophisticated enough to do that, but that's probably the way it should come out if you're concerned about it. But I initially would take the position that's the law. If you want to sue us. But if you want to get a resolution, and somebody should do that. I mean, somebody should figure that out and get a good decision now rather than waiting till later on. The question is, so when you say Rule 66 at federal court?
No, that's in state court where you don't even have to have a filing. If both parties agree to submit an issue to a judge, you can call up Judge Ellis and say, we want to submit something under this rule, get a binding decision that's not appealable.
So in other words, you're getting a state court decision on what is really a federal issue.
Basically, yeah, just to resolve whatever it is. And,
We might want to find out what judge that kind of.
Yeah, I think that would be very important. One of the things that I think was mentioned in one of the questions, we already know that the language in the plan is terrible against the insured, but under the Ninth Circuit cases, you still don't have to reimbursement. You don't have to reimburse. What if they send you one of these trust agreements so that not only do you have the bad plan language, but you have this trust agreement that your client is forced to sign, and sometimes the attorney is supposed to sign off on it too. But you have this trust agreement that says you absolutely must reimburse this plan, and we'll give you a break and not go after all the attorney's fees. Sometimes they'll throw that in there. Under the Ninth Circuit case, even though they had this extra thing that the plaintiff has done to try and hook them in, still there was no right of reimbursement. I'll just read a paragraph. I think it was the third paragraph of the opinion in Reynolds Metals. The plan contains a contractual reimbursement provision which states, if the plans paid for health care services, supplies, or treatment, and you receive payment from a third party, you must reimburse the plans, but not more than the amount of the third-party payment you received. So that was nice of them. You don't have to reimburse more than the settlement amount. Then it goes on to say the plan further specifies that reimbursement is required whether payments received are partly or entirely for health care expenses as the result of a legal settlement or other action arising from an accident, injury, or illness. So they wanted to make sure that not only do they get all your economic damages, but they get your non-economics too. I'm going to read another paragraph from the Reynolds Metals case. In Owens, which is one of the earlier cases, FMC, another earlier case, these are the three cases, an ERISA fiduciary brought suit against Jeffrey Owens, an FMC employee and beneficiary of the ERISA plan, to enforce a contractual reimbursement provision. Owens was injured in an automobile accident. As a result of the accident, FMC paid benefits to Owens totaling roughly $50,000. So $50,000 in ERISA benefits. Owens subsequently settled his claim against the driver of the other car for $100,000. The FMC plan includes a contractual reimbursement provision. Prior to paying benefits, FMC also required that Owens sign an additional agreement restating his reimbursement obligation. So they were kind of doubling it up now, as I just mentioned. And the court said, this obligation notwithstanding, Owens refused to reimburse FMC for the benefits he had received. FMC brought suit in federal court seeking to obtain equitable reimbursement. Reynolds Metals admits that its appeal is effectively indistinguishable from Owens, and that it is an effort by an ERISA fiduciary to enforce contractual reimbursement provisions against beneficiaries. While it is true that the plaintiff here couched its remedial prayers in equitable language, the plaintiff in this case being an insurance company, it is clear that a court must look to the substance of the remedy sought rather than the label placed on that remedy. Although they often dance around the word, what petitioners in fact seek is nothing other than compensatory damages. We decline to extend the interpretation of Section 1132A3 to include a claim for reimbursement. So when the carriers start telling you that there's some exceptions to this rule of reimbursement, I don't think any of the cases in the Ninth Circuit support that. So next question. Do you have to reimburse the ERISA plan in strict compliance with the terms of the ERISA plan? That's pretty much been answered already. Doesn't matter what the plan says. You don't have to reimburse in the Ninth Circuit. There's no equitable remedy to reimbursement. And as I stated, the novel approach is trying to call an injunction also failed. The third question, do you have to comply with Oregon law, federal law, ERISA law, and has a lien been created? Obviously, you're looking strictly to ERISA law here. So ERISA, the statutory law with respect to ERISA, that is what you're relying on. And even though we may not do a lot of federal law or ERISA interpretation, the cases are pretty clear. The make-whole doctrine, why even make that argument? I think it just bolsters your case when you're negotiating with the carrier. If you've got a situation where your total benefits are not that high compared to what your damages are, you can make the make-whole rule as a secondary argument. So even if the U.S. Supreme Court strikes down the Reynolds-Metals cases, you've still got the make-whole argument that survives the Ninth Circuit, that the plaintiff must be made whole before reimbursement occurs. Yes?
I don't know if maybe we should answer this or not, but as I read some of the prior materials, it appeared that if the plan wrote in that you don't have to comply with the make-whole and discretion, that just throw our argument out the window. So we lose on that, even though we're making these arguments in letters to employers.
Yes.
I didn't do it in my last one because it clearly was written out of the plan.
Yeah, it's a gap filler. And the Ninth Circuit says that in Barnes. That's if we lose this, the benefit of this rule in the Ninth Circuit, then that's going to be really what's left, other than attorney fees. But again, the plan can exclude that.
So that's not going to save the day.
Are you going to talk about future benefits?
I will. Future benefits. I don't, and Megan might know the case law better than me, but again, I'm going to resort to the practical approach. But Megan, feel free to pipe in. Okay, you've got somebody that's cutting off, you got a carrier that's cutting off your client's future benefits because you will not reimburse them. And under my example, you don't want to litigate it. I mean, it's Steve. I'm Steve. I got my 500 grand. I want to move on to the next one. And with Steve, he's got like 2 of those every month, so he's got to get on to the next one. So what do you do? Here's what I would do. I would, number one, you got to look and see what plan the person is on. And these are always employee plans, their private benefit plan that we all have, and say to yourself, is there a way that I can switch from the Kaiser plan to another plan within my employer? Some employers have multiple plans. Hewlett-Packard, you can get multiple plans. I would switch my client from one plan to another, making sure there's not some pre-existing provision in there, but moving them out to another plan within the employer. If you can't do that, my firm, you got one plan, that's all you can do. I would consider moving the client out to an independent private plan. So they're giving up their employer benefit even though it was maybe for free, and they got to pay another $400 or $500 a month for some private plan. And if you're talking about reimbursing 100 grand, maybe that's the choice you make, that the person has to move out to some private plan. And as you know, the carriers are ruthless. They don't care how bad your client is injured. They don't care what the law says. A lot of these plans are going to cut off future benefits. And that's just the way it is. And so you got to make some hard decisions. The best thing is for Chuck Tomlin to litigate this issue and get a decision when somebody's benefits are cut off. I mean, these are pretty egregious cases, especially on serious injuries, where a carrier somebody's actively paying their premiums and the carrier refuses to pay the benefits. And especially in light of the Ninth Circuit cases, which says they're really not entitled to reimbursement, to cut off somebody's benefits is pretty egregious. In the, a bad faith case, Gene Hallman in even a PIP denial case got a great verdict a few months ago down in one of the southern counties. Basically, they cut off the person's PIP benefits, didn't have a right to. He sued on a simple breach of contract claim and got consequential damages of $250,000 or $350,000. So on that kind of a case with just PIP denial, juries are awarding money. If we can get an ERISA case going where they're cutting off benefits to somebody that badly needs the benefits, I think that's a good case. Chuck Tallman. What are your legal and ethical obligations to your client? And I talked about this a little bit to respond to Chuck's question, but I think when you get right down to it, the bottom line, I will admit, in a lot of these cases, I do just work it out with the carrier. I say to them, here's the law, we don't owe you anything, and it just is a basis for me to push them down on the amount that I'm going to pay them. Because when I explain it to the clients that, maybe I can give you this money and maybe they can come back after you someday, the clients a lot of times, if it's not a real big amount, pretty much just want to move on too. And so I never pay more than 50% of what the lien amount is. And most of the carriers that I've dealt with, that's kind of their standard, even though once you get beyond of all the BS about, well, I've never heard of these Ninth Circuit cases, they'll usually reduce their well, I call it a lien sometimes, it's not a lien. They'll reduce their right of reimbursement to about 50%, and then you just come to an agreement and you're done with it. So that's one option, but again, I think someone needs to litigate this issue. There was even talk of a class action case for somebody to go back into the past and get all this money that was improperly paid to ERISA carriers, which is big dollars. There's the people that I've talked to that have looked at the issue, it makes it kind of a difficult case because, a lot of times these people were represented by an attorney and they did cut a deal, or the attorney paid the ERISA carrier the whole thing back. So it would have to be characterized as some type of a fraud case, but that's a tough case. Legal and ethical obligations. Pardon me?
What did your lawyer say?
My lawyer said, my Bullivant lawyer said, Tom, you made a pretty good fee on the case. Why don't you just pay him the money? That's what he said. And, he's from that PIP mindset that, you just give them all their money back. That's the American way. And so that was his mindset. But then he started reading some of the cases, and he sort of came around. Didn't come around enough to get nasty about it. He still wanted to be friendly with the other guy. Some Darren Lee in Eugene or something for Liberty Northwest, some in-house counsel. Does anybody know him?
Yeah.
Well, I don't like him. I'm sure he's being told what to do. But you don't make bar complaints and threaten lawsuits when the law is not even in your favor. At least I don't think you should. But that's the position he's taken. And even when we sent him all the cases, he didn't change his position. He still was making the threats. So one of the questions you have to have, if you really want to go and fight them hard, you got to make the decision whether you want to, there's talk of putting the money aside and have it interpled, but are you violating your duty to your client if the client wants the money and you're putting it aside just because somebody's making a claim for it? I've got a problem with that. But I think the Oregon State Bar ethics people think that's what you should do. If there's a dispute about the funds, you're supposed to leave it in your trust account, notwithstanding the law says the insurer has no rights. And I think what's happening is insurers, just like we see every day in our courthouse, are treated differently than everybody else. People think there's some extra protection that insurers should get. Mike?
I called the bar about 2 years ago on that very question, and the woman I spoke to agonized about the question and said, well, I think you need to give the money to the client. So you just said they're telling you the opposite? Hang on to it?
Well, no. We called, in my case, we called George Reamer and talked to him about it. And he... Well, as we know, that means nothing. But he did say that you really do have a duty to your client to pay them out the money. But I think Sylvia Stevens has a different approach. I think the mindset is that you're just a plaintiff lawyer making trouble, and why would you get yourself into this when you can just set the money aside and let it be fought out? So it's a mixed message.
Yeah, the other problem you have is that the client could be sued, and the client could have to pay attorney fees to the ERISA plan, and you've got to tell the client that, and then the client may not want to get this, may have some different thoughts about it.
Sure, and you've got to do that in a letter to the client and lay it all out. And most of the times, like I said, the client is not going to want to deal with some potential lawsuit that maybe will be in their favor in the future, and you cut a deal with the ERISA carrier. Yes?
Maybe this is more directed at Megan. I have a couple of cases involving Oregon and Washington carpenters union, and I heard from a couple of you that you've settled yours either in full or 50%, and I'm getting letters rejecting that totally. What about unequal treatment to various members where some get their dues waived and others don't?
I'll let Megan answer that one. Or try to answer that one. I don't know, I think the argument might be, we negotiate these things all the time. Chuck is going to be arguing this issue, so we'll let him talk about it.
Well, see, the legal standard is going to be what is in the best interest of the plan's beneficiaries and participants. So the plan can argue that what's in the best interest of the members of this plan is to spend as little in legal fees as possible and to negotiate this on a case-by-case basis. So I don't see there being any sort of, kind of equal protection-like argument that I got a worse deal than this one.
And we've talked about this, but my sort of last question, what steps can be taken to protect you, the client? What are your obligations after the funds are paid and the file is closed? What are the client's obligations? And I do want to emphasize what's already been said, that your client is at risk if you give them the money. If the U.S. Supreme Court reverses, then they're going to owe the money. If you get in front of one of the backward judges in Oregon that was schooled in PIP reimbursement, and insurance carriers are always supposed to get reimbursed, you may get a bad district court decision, or someone's going to force you up to the Ninth Circuit, which we don't always want to do after a case is over with. So I don't mean to say that after the case is settled, you just pack up your bags and don't reimburse the ERISA carrier at all. You need to take certain steps to protect yourself, and those are CYA letters to both the carrier and your client, and clearly lay out what the client's potential pitfalls are in the future. Steve.
What is the statute of limitations for the carrier to wait for the Supreme Court for reversal?
Megan, do you know? I mean, if it was a state issue, you'd get the 6-year contract. I don't know what the statute of limitations would be.
And I don't know, I can't recall whether it's blanking on this, whether health plans typically have a 3-year provision built in there. And if they do, whether that's enforceable. I think it would be, and I suspect that most health plans. Does anyone know? I suspect most health plans have written in a 3-year statute of limitations, and then, go back to David's question, 3 years from what?
Well, it depends on what the Supreme Court says. I would think if they say, well, it's in nature of a lien, look at Oregon lien law, and they have 30 days. Change it.
Yeah, and I mean, we know in this state, in the PIP context, they can write, even though it's a 6-year statute of limitations, they can write in a 2-year statute of limitations, and that has got some people on some malpractice claims because they were just thinking 6 years. Other states, you can't just write in a statute of limitations in a PIP contract, but in Oregon, apparently you can. Mike.
Rationale in answer to Steve's question, most of them seem to go in this unjust enrichment theory that they're the Sixth, First, Fourth, Fifth Circuits, I think, have all bought. That the reason that these claims are allowed, they're equitable claims because the plaintiff has been unjustly enriched. The Ninth Circuit has said, with regard to the argument of unjust enrichment, what the other is constructive trust, you have to show that there is some ill-gotten goods, and they haven't been. So that's really, it seems to me more than anything else, that argument is what they're relying on.
And I would make one point on that. A lot of judges here think it's, you know, the unjust enrichment because, not just this context, but all contexts, that this plaintiff is getting a double recovery. Not only have they recovered the medical benefits, now they're recovering them again. The argument to that is it's not a double recovery. In the real world, your client has paid premiums for that benefit. And so they've already gone out of pocket for those premiums. And so therefore, they're entitled to get the money back and keep it because they've paid for that benefit. I've tried to explain that issue to judges, and here they don't get it.
And once you get into the equitable issues, then you're into the common fund theory and you're into the made whole theory. And how do the courts interpret that in the other circuits?
In the other circuits, well, generally speaking, the rule is the same as in the Ninth Circuit. If it's not, well, if these cases are reversed and there is a right to reimbursement, then, you know, given that in the other circuits, the courts say the make whole rule is a gap filler. There are a few courts who have said make whole rule doesn't apply. Where this gets really tricky, I was going to go back to this, but I'll touch on it now. The common fund doctrine, that's the gap filler that says if the plan doesn't have a provision to the contrary, there's a cut for attorney fees, the cut lien for attorney fees. And there are a couple, there's a split on this issue. What if the plan is silent on that issue? There are some cases where if the standard of review is abuse of discretion, several courts have said the plan administrator can interpret that silence in the plan to mean that there is no entitlement to a cut for attorney fees. The Ninth Circuit obviously hasn't decided the issue because it really isn't going to come up unless there's a reversal of the Woodson case. But so the courts are kind of all over the place. Generally speaking, they will write in both the attorney fee reduction rule, the common fund doctrine, and make whole rule, unless the plan excludes it, and the plans can exclude it. That's very easy for them to do. There was some language in FMC that I thought was important that really kind of goes to the heart of what the Ninth Circuit, why the Ninth Circuit has decided these cases the way it has. Really, it's just amazing how the others define logic. Relying on Mertens, they say, or Sedgwick, they say, although they often dance around the word, what the plans in fact seek is nothing other than compensatory damages, monetary relief for all losses their plans sustain as a result of the alleged breach of fiduciary duty. Money damages are, of course, the classic form of legal relief. And that goes right back to what the court in FMC said. Even though you may have a clause that is calling itself a subrogation clause, the court in FMC said, let's look at what the plan is actually claiming in this case. And even if it is a subrogation clause, if the plan is looking to get its money back, it's looking for reimbursement. So I think that there's a hope that even if you've got a subrogation clause, as long as the reimbursement rule stays in the Ninth Circuit, even if it's a subrogation clause, 99% of the time the plan hasn't done anything to step into the shoes of the, to collect money, to step into the shoes of the injured party, to collect. So there's that hope. Futures, there's one case on future benefits. No one litigates this because it's a horrible thing to litigate, but I'll just give it to you for the site for anyone who's interested. Davis versus NEPCO, capital letters, NPCO, 51 F 3rd 752. That's a Seventh Circuit case. It's kind of an odd case, but it does discuss future benefits. In that case, the plan, I think the way it went was the plan ended up being very involved in settlement negotiations and a party to the settlement agreement and didn't protect itself as to future benefits. So the court held that it was not entitled to cut off future benefits. But that's the only case that I know of where anybody really got into that issue. Oh, I wanted to raise this one other issue. This just came up in our office, and this is a mess. And right now we're okay on it, but we're probably going to end up litigating this because there's a lot of money at stake. This is a third-party case. Arose out of a workers' comp claim, and here's what happened. The workers' comp claim was denied. Person then, this is typical, went to their ERISA plan. The plan paid quite a bit in the way of benefits on the denied conditions. There were two. The comp case ended up being settled with the CDA and the DCS, where the denials were specifically upheld. So nothing changed there. Now the plan comes and says it wants its money back and says it's going to cut the client off for future benefits. They say, what the plan says is, we're entitled to reimbursement, subrogation, they call it subrogation, for money for injuries arising out of employment. So, of course, our argument has been, well, these injuries don't arise out of employment. That's been proved and affirmed in the workers' comp case. And this is a savvy plan administrator. They've said, well, there's an abuse of discretion standard of review under this plan. Your client filed an 801 claiming that these injuries did arise out of employment, and although every doctor has said to the contrary, it's been asserted that these arose out of employment. So we're going to rely on that, and we're sure that the court is going to say that that's not an abuse of discretion. So it's a mess. And right now, Ninth Circuit, no reimbursement, and they know that. Who knows? Maybe we'll be able to settle it, but it would pretty much eat up the comp. I think it would eat up the whole comp settlement if they're entitled to reimbursement. So.
Case right now?
Yeah. Well, it hasn't been filed. It's being kicked around with the the insurance company trying to decide what we're allowed to do, but I mean, it's just the ramifications of reversing that rule in the Ninth Circuit. If that's what, for example, a health plan's going to start saying in a comp context, it just seems like a disaster. Anyway. On that note.
Is the right to bar, or the alleged right to bar future medicals restricted to the condition that was the subject of the case that we might have worked on? For example, if the plaintiff settled a back condition and continues treating for a back condition, they're going to try to bar those bills, obviously. But if they develop some other condition or they have some other chronic condition, are they trying to bar payment on other medical claims?
I haven't.
You have?
Yeah.
They want to borrow all
Legal
of it.
injury, and she needs a knee replacement, unrelated, and they're borrowing for future.
Yeah, I mean, you gotta look at the mindset of the carriers, and yeah, I would say absolutely, in every case, they're gonna try and stop everything because you haven't paid them back.
And they're saying this offset is equitable.
I think I've read in a Blue Cross plan that it was limited to the same body part, so it's obvious we need to take a close look at those future medical clauses.
Well, has anybody actually, the insurance sued or clients over this? Because every time Blue Cross has gone after one of our clients on such a thing, we threatened to sue them, and they always back down. They back down every time. They've never tried to enforce the future rights clause.
It's hard when you're dealing with Blue Cross, and I agree, I've had the same experience with Regents in Oregon, and I'm dealing now with Blue Cross in Massachusetts, and they don't care what the Ninth Circuit rule is. They don't care if we're going to sue them,
I'm not talking just ERISA here, I'm talking about
Right.
in or out of ERISA.
Some leverage you have on that is, particularly with Blue Cross, if you assert a common fund theory of attorney fees, and you're saying, well, it's also going to apply to future benefits, your attorney fees will wipe out their entire claim.
Right,
So you're 1/3 of not just what they paid in the past, but of what their future exposure is.
The point to be made, I guess, for non-ERISA plans, there are those certain plans that are non-ERISA, and unfortunately, what happens with those is Oregon law applies. And they're probably going to apply the provisions of the plan, and if you've got a non-ERISA plan, you may have to give them back everything. And so that's also one of the arguments that the ERISA plan folks make, is that they're not an ERISA plan. So get the plan and find out if it's really an ERISA plan or not. And I've watched the ethical opinions here in Oregon pretty closely, and in the PIP context, if you try this, it is a violation. If you don't pay back the PIP carrier, you will be sanctioned. So that kind of goes against the grain of most of us that are very fearful of getting sanctioned, and that's part of the threat that's used to coerce you to breach your ethical duty to your client and pay off the carrier.